Hi, everybody. I am happy to be here with you virtually at the Oregon Housing Conference. Welcome to my update on Martin v. Boise. That's an important federal appeals court case that I will be telling you about. I'm Maria Foscarinis. I'm the founder of the National Homelessness Law Center, an organization I started in 1989 to serve as the legal arm of the national movement to end homelessness in America. I'm also the former executive director of the organization. I stepped down from that role about 2 years ago, and now I am working on a book about homelessness, and I am also teaching as an adjunct at Columbia Law School about homelessness law and policy. So, first off, I want to give you a little bit of background about the criminalization of homelessness, which is what this case, Martin v. Boise, is about. So criminalization, and I don't know if you're all familiar with the term, but it's been a growing trend since the 1990s. And what criminalization refers to is restrictions and or prohibitions on the use of public space by homeless people, people living in public, laws against sitting, sleeping, camping. Sleeping is sometimes referred to as camping in public, urinating, defecating in public spaces, in the absence of other options. This is important. So criminalizing people's public presence when they have no other choice but to be in public, to live in public. Restrictions or prohibitions on begging in public, sometimes referred to as panhandling, are also part of criminalization. The National Homelessness Law Center has been tracking this trend since really the beginning. Our first report on this was in 1991. And we've been publishing periodic reports on the issue for years. So we've been tracking trends. And the trend is that these kinds of laws are growing and they're becoming more and more specific, more sophisticated, and covering a broader span of activities. One striking data point is that there was a 213% increase in prohibitions on vehicle habitation, living in your car or other vehicle, from 2006 to 2016. And this most likely tracks the fact that as housing costs are skyrocketing, more and more people are living in their cars or RVs or other vehicles. Another important new trend that we have found is that increasingly state laws are targeting public presence of homeless people. So this trend initially was primarily at the local level. In other words, cities were passing laws, often called ordinances, that were criminalizing people for being in public. Now, state laws are being enacted, covering people's living on state property, but also in many cases requiring cities to enforce laws criminalizing homelessness. And in a disturbing new trend, to fund shelter, not housing. I'll talk a little bit more about this towards the end of my presentation. So in response, advocates have been fighting back, and litigation has been a critical tool in that response. And there have been a number of cases brought over the years and precedents set. Precedents have gone in either direction, but more recently, the precedents have been positive, in other words, protective of homeless people. And the most recent major case is a case called Martin v. Boise. That was decided in 2018. it was just last year reaffirmed by another case, again in the Ninth Circuit, called Johnson v. Grants Pass. Grants Pass is a city in Oregon, as you may know. So I'll talk about Martin v. Boise first. That was filed in 2009, and it was decided in 2018, as I said. So this has been a long-running case. It went up and down. It was appealed. It went back down to the lower court. It was appealed again. And the end result was this 2018 decision by the Ninth Circuit, the Federal Court of Appeals for the Ninth Circuit. So by the time the court was issuing its ruling, it had these facts in front of it. So by 2016, which was the most recent information available to it, there were at least 867 people who were homeless in Boise, the city where the case arose, Boise, Idaho. And that was according to the point in time count, the pit count, which, as many of you may know, is likely is often a severe undercount, but at least 867 people. There were 3 shelters, and they had a total of 354 beds plus 62 overflow 62 overflow beds. 2 of the 3 shelters were religious. They had religious iconography on the walls and within the facilities, and they were time limited. You could only stay for, I think, 17 days. To stay longer than that, you had to enter an explicitly religious program, discipleship, they called it. And they had curfews. The 3rd shelter, which didn't have these characteristics, was often full and also had time limits. So these were the facts that were before the court. And the court ruled, and I'm going to quote this. I've got the epigram that was at the very beginning of the court's decision. It's a quote from Anatole France, and you may have heard this, but it's about how law, in its quote, majestic equality, forbids both the rich and poor from sleeping under bridges and begging in the streets. And of course, it's a commentary on the fact that in reality, only poor people are doing these things. So that was how the court prefaced its decision. I should also note, as I said in the previous slide, that the Department of Justice, this is important, the Department of Justice weighed in on the side of the homeless plaintiffs in this case. And I say on our side because my organization, the National Homelessness Law Center, was one of 2 groups litigating this case. We were together with the Idaho Legal Aid Services. And we also, importantly, had pro bono help from a big law firm, Latham and Watkins. So the Department of Justice weighed in 2015, submitting an amicus brief, what's called an amicus brief. That's a friend of court brief. So basically agreeing with us, and we had sought this. We wanted the federal government to take a stand, because a problem with litigating this type of case is that you might challenge one ordinance in one city, you might win, you might strike down a particular city's ordinance, but then another city will do the same thing, another ordinance will pop up. And so we wanted the federal government to weigh in so that we could say, look, this is a federal issue, federal Department of Justice is weighing in. Of course, we also thought it would strengthen our hand in this particular case, and it probably did, because, as we'll go back to this slide, the decision was very favorable. And the court said that if there's no other option to then, except for sleeping outside, then you cannot criminally punish people for sleeping in public. And the court said this is unconstitutional. It's unconstitutional because it violates the Eighth Amendment to the U.S. Constitution. That's the amendment that says you can't have cruel and unusual punishment. It's a prohibition on cruel and unusual punishment in a criminal proceeding. So the court said this applies, it's cruel and unusual punishment to criminally punish somebody for sleeping outside when they have no other choice. Now, what does no other choice mean? It means there's no shelter available, and it has to be adequate and practically available. It was the language that the court used. So it's not just a number issue. It's not just a matter of there being more shelter beds available than homeless people, but the shelter has to be practically available. It has to be adequate. And, those are terms that leave some room for interpretation. In this case, there was no question that there was not enough shelter, that numerically there wasn't enough shelter, and also the religious aspects of the shelter that was available was problematic because it ran into another potential constitutional violation of freedom of religion. That wasn't the basis, though, for the decision. The basis was that there was no other shelter that was practically available. So that ruling happened in 2018, and the city of Boise asked for what's called rehearing en banc, which means that the city asked the full Ninth Circuit, all the judges in the Ninth Circuit, to review the decision. The way this works is that the Federal Court of Appeals consists of a 3-judge panel. So it was this 3-judge panel that issued this ruling. But there are many more judges on the Ninth Circuit, and the city asked the whole Ninth Circuit to review it, and the whole Ninth Circuit denied review. And there were some dissents, but the result was it denied review. Then the city went to the Supreme Court asking it to review the decision, and the Supreme Court denied review, which we were all very relieved by. There was a pitched battle in front of the Supreme Court, briefs. There's a pitched battle with briefs on either side, and we, the advocates, were arguing that this did not merit Supreme Court review. We had many other advocates on our side. The city had cities and mobilized its allies to argue that there should be Supreme Court review, but the end result, thankfully, was denial of review. So what does this mean? What was the impact? So the decision in Martin v. Boise is binding in the Ninth Circuit, and the Ninth Circuit is a big circuit. It includes 9 states, and I've listed them here. You can see them, and 2 territories. And cities responded in different ways. In the immediate aftermath, a number of cities repealed ordinances that criminalized homelessness. Some stopped enforcing their ordinances. Some opened more shelters. Others launched other initiatives, including housing, in order to have alternatives, with the hope that if they had sufficient alternatives, then these types of ordinances could be constitutionally enforced. Not all cities complied, though, and there were still sweeps, and has been and still is, continued litigation based on the Martin precedent, challenging these sweeps. When the pandemic came, the CDC issued guidelines which, noted the increased vulnerability of homeless people to COVID and urged cities to place people to the extent possible in individual housing, so not in congregate shelters, not leaving people on the streets, but also saying if this was not possible and people had to be on the streets, then encouraging them, urging them to ensure social distancing. So in encampments, to have people at a distance, 6-foot distance from each other, and to have porta potties and hand washing stations at encampments, which is probably a good idea anyway, apart from COVID. But the CDC guidance, which advocates push for, including us, the CDC guidance actually urged cities to do this, and many did. So, but other cities, during the pandemic and after the pandemic, tried to get around this Martin v. Boise ruling. And one of those cities was Grants Pass. So Grants Pass, I'll talk about in more detail in a moment, but Grants Pass passed an ordinance or enacted an ordinance it thought could evade the ruling. Cities are still conducting sweeps, and the ruling is still being challenged. And in fact, just recently, a few days ago, the county of Sacramento sued the city of Sacramento to try to make it enforce sweeps. And this was actually written up in the New York Times on September 20th. So you can check that out if you're interested. Meanwhile, at the federal level, the U.S. Interagency Council on Homelessness, the lead federal agency charged with leading federal efforts to address homelessness, has condemned sweeps repeatedly, including and criminalization generally, including in the most recent federal strategic plan to end homelessness. And yet, despite that, the Federal Park Service has conducted sweeps, which is extremely disappointing. So I'll tell you now about the Grants Pass litigation. The case is called Johnson v. Grants Pass. In that case, the city imposed a civil penalty for sleeping in public with a blanket or other bedding. And it argued that because it was a civil penalty, not a criminal penalty, it was different. It didn't come under Martin v. Boise because Martin v. Boise applies to criminal cases, and that's because the Eighth Amendment applies to criminal punishment. The Ninth Circuit, this eventually came up to the Ninth Circuit, and the Ninth Circuit reaffirmed Martin, and it said, no, you can't do this, Grants Pass, because this ordinance imposed a civil penalty. But the civil penalty, and what that did is it resulted in a citation, and a fine, but if you didn't pay that, it turned into a criminal penalty. So you could be arrested and criminally punished if the fine was not paid. And so all that this change that Grants Pass made did was include an additional step. So rather than go immediately to criminal punishment, it imposed a civil penalty first. But the court said you can't get around Martin that way. And the city also argued that because it included prohibition on blankets and other bedding, that that distinguished it, although there was blanket and bedding present in Martin as well. So the court said that doesn't matter. Blankets and bedding are essential protection from the elements that you need in order to sleep, and they're part of sleeping. And so that didn't matter to the court. So this is basically reaffirmed Martin v. Boise and extended it a little bit because it also applied it to civil penalties if there's a possibility of criminal penalty. And again, the city asked for rehearing en banc, asked for the whole Ninth Circuit to hear the case. That was denied. But this time there were more dissents and some very vigorous dissents. And based in part on this, the city is now asking the Supreme Court to review. And that has not yet been resolved. So again, there's this specter of possible Supreme Court review, which advocates are fearful about what this Supreme Court could do. If that happens, the outcome is really up for grabs. There's no telling what this Supreme Court might do. And that's even though the theory of the Martin v. Boise case is based on old and established Supreme Court precedent, which basically says you can't criminalize status. You can't punish someone for something that they can't control. And it's otherwise harmless. So for example, you can't punish someone for being an alcoholic. You can't punish someone criminally. Can't criminally punish someone for being a drug addict. That's punishing status, and you can't do that under the Eighth Amendment. Those were the contexts that the Supreme Court's prior rulings were in from decades ago. So they weren't exactly in this context, they weren't addressing homelessness explicitly. But the idea is that if you're homeless and you have no other, and you're living on the street because you have no other place that you can be, then that's involuntary conduct, and it's necessary, and it's otherwise harmless, and it's necessary life-sustaining conduct, and everybody has to sleep. So you're essentially punishing the status of existing for a homeless person if you're punishing them for sleeping in public. So that's the basis. And it has this Supreme Court grounding in Supreme Court precedent, but we know that this Supreme Court in particular is not necessarily averse to overturning past precedent. So there's concern about what might happen if the Supreme Court grants review. The other kind of danger point I want to touch on is that there's a group called the Cicero Institute that was started by a tech billionaire. It's very well funded. It's a very it's a right-wing group, although it calls itself a bipartisan think tank, but it is promoting some dangerous ideas, including statewide laws criminalizing homelessness. And I mentioned that this is now a trend, and the Cicero Institute has a model law, a template of a model law that it's promoting. And in addition, diverting housing funds to short-term responses to homelessness, like shelters and legalized encampments. And this is gaining some traction now. Some states have enacted laws based on the Cicero template. So advocates are fighting these trends, and I at least think that's a good thing, but I also think it's not enough. Fighting criminalization is not enough. It's a defensive posture. And we also, as advocates, I think, need to be careful not to be advocating for a right to live on the street, I don't think that's what anybody wants. I think there is a potential common ground in that everyone can agree that for people to be living in public on the street in a country that has the wealth that ours has is not any is not something anybody wants. It's actually an outrage. It should not be happening. So, but the position of advocacy is that the response should not be to criminalize people for living or for sleeping, for doing necessary things for their survival, but the response should be creating alternatives, and that those alternatives should be housing. There's a lot of evidence that housing first works, that housing first is the solution to homelessness, but the housing first is not being implemented on the scale by far needed to actually solve the problem. It's not getting the funding it needs. Doesn't have the support it needs to be to solve the problem, and certainly to make up for all the cuts to low-income housing that have been made at the federal level as well as other levels, but primarily at the federal level over the past 40 years. But I also want to add a note of optimism and hope, which is that there is increased energy and activism in the United States, especially at the state and local level, but also the congressional level, for what's called social housing, which is a term that's used. It's a little bit broader than public housing, which has gotten a bad rap here in the United States. But in other countries, there's this concept of social housing, which is housing that is not limited to poor people, but includes poor people and extremely poor people, but it's broader than that. And it has more support. And there are now campaigns at the state and local level around the country that are advocating for this. In Seattle, there's a interesting recent campaign that was that just succeeded by Real Change, which is the street newspaper there. They had a campaign that grew out of their fight against sweeps and grew into a campaign for social housing. And that potentially could be a model. So fighting sweeps, but also fighting for housing. There's now in California a campaign to include the right to housing in the state constitution. And this is gaining traction. It's happening right now. And it's something that a number of different advocacy groups are involved in, including the National Homelessness Law Center, but local advocates like LA CAN, which is a grassroots advocacy organization, are pushing for this. And in 2016, the Law Center and the National Coalition for the Homeless launched a campaign called Housing Not Handcuffs. And I put the website of the campaign up on the screen. But that's a campaign to link these efforts together so that it's not just fighting defensively against criminalization, but also fighting for something proactive, the right to housing and the human right to housing, because housing is a human right. It's recognized in international human rights law as a human right. It's just that here in the United States, we have not recognized it as yet, but I and many advocates think that we must do that. There's more information about everything I talked about at the Law Center website, and that I put up as well. So thank you very much. I will leave it at that.